I want to say at the outset that it's certainly an honor to be sitting on a panel with such prestigious co-panelists, and it's a pleasure to be here at this conference. I'd also like to begin with two disclaimers. First of all, I'm not someone who's going to be speaking from the perspective of a defense lawyer's reflexive disapproval of litigation funding. I receive litigation funding, and I frequently act on behalf of investors as plaintiffs. So my perspective, I think, is more one that I hope I can identify some things that the lawyers and the investors in the audience might want to think about, and some problems they might hope to avoid. The second disclaimer is that, as I think many of you know here, that my case is in some way responsible for the absence of Martin Kenny from the conference this year. Mr. Kenny, I understand, is a loyal member of this conference, or a loyal participant. I hope by the end of this presentation, you all will have some understanding of how those events have turned out. I apologize to his friends for depriving you of his company this year. So with those disclaimers out of the way, this case I want to talk about is about an effort to enforce a Liberian judgment in the Cayman Islands against the indemnitor of the party who is purportedly liable for that Liberian judgment. And I'll have to spend a few minutes explaining the background to understand how things came out with this. Let's look first at where the Liberian judgment came from. Some time ago, actually, a very long time ago, a Liberian insurance policyholder called AJA suffered property damage as a result of the truly horrific Liberian Civil War. They came to the U.S., sued Cigna in a declaratory judgment action seeking coverage. The judge in that case ruled that there was no coverage because of the war risk exclusion. He concluded that, as a matter of fact, the destruction of the property was the result of war and therefore fell under the war risk exclusion. AJA appealed that. The Third Circuit agreed with the district court, and the Supreme Court refused to take cert. Following that, AJA went back to Liberia, litigated exactly the same case, and obtained a judgment in its favor for $66 million.
Was the proceeding in Liberia contested?
Cigna showed up long enough to point out that there had been a prior American decision. The Liberian court said, we're going to disregard the U.S. decision because it was reached on a JNOV, and in Liberia we don't recognize JNOVs. And after that, Cigna did not appear, so it was uncontested after that point. So Cigna then goes back to the Eastern District and obtains an anti-suit injunction against enforcement of that Liberian judgment. And that was where matters stood for some time until some other parties became aware of the existence of that judgment and decided they were going to try to capitalize on it. And as we've eventually learned, the key actors in this were two attorneys, Mr. Kenny and Samuel Lohman. Lohman is a U.S. citizen but was resident in Switzerland. They came up with the rather creative idea of getting the Liberian Insurance Commissioner to create a receivership for Cigna's operations in Liberia. Cigna had ceased to do business in Liberia by this point. The Liberian Insurance Commissioner, acting as receiver, then recognized the $66 million judgment as a legitimate debt of Cigna, even though Cigna remained an extant U.S. corporation at the time. And meanwhile, an insurer called ACE, now known as Chubb, had entered into business transactions with Cigna and had purchased a large part of Cigna's operations and agreed in in the course of that deal to indemnify Cigna. So the plan was for the receiver to show up in a jurisdiction where ACE had assets and to say, hey, I'm Cigna, I'm acting for Cigna, and I want to realize on this judgment under ACE's indemnity. And that plan was eventually executed in the Cayman Islands, where ACE was domiciled at the time. The other players in this, as we learned many years later, and I will explain how long it took and why it took so long, were Garrett Kelleher, an Irish property developer who made this whole operation possible by putting in about $3 million, and Echimus, which is an entity that was largely controlled by Burford, which played a very minor role, came in late in the day. Now, as to what happened to these folks in the end, yes, okay, Echimus ended up settling in the Cayman Islands for a very small amount, just $100,000, but it had caught liability as a funder. Samuel Neuman was held in contempt in the U.S. When he finally appeared, his passport was seized until he provided us discovery into his assets. We settled with him for a relatively small amount based on his very limited ability to pay. Martin Kenny was held in contempt last year. He has not appeared. In the Cayman Islands, he was also held liable for costs, which is an interesting point I'll come back to shortly. And there is now an arrest warrant outstanding for him in the U.S. And Garrett Kelleher never appeared. He has been held in contempt. There is a U.S. arrest warrant outstanding for him as well. Now, as to why Martin Kenny was held liable for costs in a cost jurisdiction, it was not because he was a funder. He was held liable as an attorney, which is something that might give chills to any of us who practice in cost-shifting jurisdictions. The reason was that the court found as a matter of fact, that Mr. Kenny was likely to be found to be ultimately responsible for controlling the case, and that he had put forward the receiver as a nominal party, which is a very unusual circumstance, as the court recognized. As to what happened quickly and how these folks ended up in this position, in the Cayman Islands, the case was initiated by the receiver, as I said, and that was litigated at a slow pace. Eventually, the case terminated when there was a demand for security for costs. The funders decided not to meet that demand, and the case ended. We then proceeded and obtained our costs, which are basically, under the Cayman standard, fully recovered on a standard basis against Mr. Kenny and against Echimus. In the Eastern District, once the Cayman Island case was initiated, we went back to the Eastern District and sought to hold parties in contempt, the parties who were bringing this case in Cayman. And we didn't really know who those parties were for a very long period of time. The court, initially we knew about Neuman, of course, and the court found that it had jurisdiction over Neuman and over the receiver on the basis that they were aiding and abetting the violation of a U.S. court order. And under U.S. law, the violation of a U.S. court order itself confers jurisdiction on the U.S. court over those parties. We eventually found out Kenny's central role, added him. After a long period of time, 6 years of the proceeding, we identified the litigation funder, Kelleher, added him. Those parties were all held in contempt last year. We have not yet got a quantified amount of compensatory sanctions, but it is likely to exceed $10 million. Kenny and Kelleher were required by the court to appear for a hearing in December, and the judge told them if they did not appear, he would issue an arrest warrant for them. They did not appear, and the judge has issued arrest warrants and initiated a criminal proceeding to hold them in criminal contempt. That proceeding is still ongoing. As for the identification of the litigation funder, suffice it to say, it took a very long period of time. Mr. Lohman clearly knew who it was. Despite being a U.S. citizen, he simply refused to appear for a deposition or answer interrogatories, even when ordered to do so by the court. We eventually found out about the existence of a funder called Echimus, which we knew was associated with Martin Kenny. We found someone who was associated with Echimus who was willing to talk to us, who told us that there was a litigation funder, told us the amount, told us his first name was Garrett. It took us another 3 years to find out his last name. We took discovery from every party that we could. We found a U.S. executive of that Echimus entity from whom we took a deposition, we obtained documents, we got privilege logs. Eventually, based on a long privilege battle, the court found that to the extent that there was any a privilege in the identity of the funder, it had been waived, and it was actually Mr. Kenny and Mr. Little who eventually told us that the funder was Garrett Kelleher. So that is, in a nutshell, the history of the case. I think it raises a number of interesting issues. One of them is about the long process it took us to identify this litigation funder. And while I am a big fan of litigation funding, I think there is something troubling in circumstances where the identity of a funder is relevant, that it should take so long to find out who it was. This is certainly the identity of a funder is relevant in a cost-shifting jurisdiction. It can be relevant in U.S. litigation, as it was in our case. And I would hope that other parties in our position don't have to spend as long as we did finding out who a litigation funder is who is behind the case. There is an important story here about diligence on claims, although interestingly in this case, the parties who were the motive forces here, Martin Kenny and Samuel Lohman, and the funder for that matter, were all aware of the U.S. anti-suit injunction. And they knowingly took on this risk and decided it was a risk they could handle. We learned, in fact, through discovery that the Kenny and Lohman, when they were putting together a budget for funders, had budgeted for sanctions to be paid by Lohman in the United States. So they knew what was coming. They thought it was a risk they could handle, and that was a poor decision, I think, on their part. And then finally, this raises questions about control over litigation. As I said, control over litigation led to liability for the attorney in a cost-shifting jurisdiction, certainly something to be concerned about. And control is an issue that I think is also going to continue to be important to litigation funders as well. And I think some of my co-panelists will talk about that further.
So in your case, the funder clearly wanted to stay anonymous.
Yeah, absolutely. Yes, I would think so.
From
yes,
the length of your efforts. From what you've seen in these cases, or any of the panelists, what are the best ways to discover the identity of a secret investor? And what sort of paths are available to litigants?
I would hope that some of my colleagues have better ideas than we did and could have gotten them more quickly than we did. So,
well, I will say that in some jurisdictions they're enacting or considering rules that require disclosure of funders. You know, we'll see if that becomes the norm, but certainly I agree that if there's an element of control, the identity of the funder should be known.
My case was a little different because it was litigated in London under the English system where security for costs are available to certain types of funders that I'll talk about in a little bit. The funder's identity became necessary to be known when the judge was considering ordering security for costs because the actual nominal plaintiff didn't have the capability to pay the defendant's costs in the event that they were unsuccessful. So it really was at that juncture that the court first allowed any interest into who the funders were, what their economic interests were, to be sure that the security awards that were posted, in fact, it was cash security in my case, were adequate. But before that, there was no foray into trying to determine who the funders were, and the court clearly would not have allowed that.
And I'll just add that in the Chevron cases, the identity of many people, including the funders, really came out through 1782 discovery, which if you have a foreign action, and especially if you have a U.S. funder or a U.S. participant in the litigation that's subject to a 1782 that might know the identity of the funder, that seems like a path. So I would guess the two most direct paths are probably outside of the litigation itself, in terms of an interrogatory, would either be a 1782, if available, or early on making some sort of a cost-related motion, either for a cost bond in the U.S. or for coverage either in the international or foreign fora. So there's definitely some ways you can get discovered if you're a funder, and some ways to find your funders if you're on the other side of the issue. Are there questions from the audience before we?
Can I ask a very silly question from knowledge in this area? Why is a funder liable for the actions of a lawyer in court? He's simply funding the action, but he's not the plaintiff. Or is he stepping in the shoes of the plaintiff?
I think it depends on the kind of liability you're talking about. I mean, I think in the case that Roy's going to talk about, they're in a cost-shifting jurisdiction. And so the funders were liable for costs, and there was one other element they were liable for, right?
Costs on an indemnity basis, which is a much higher percentage than the normal cost of the award, so it's a little bit unusual.
But, I mean, to the extent you're talking about liability for the fraudulent actions of a lawyer, I think that they are liable under the same theories that any third party would be, right? So it would not be easy to find them liable for reasons other than sort of cost shifting or standard judicial procedures.
And just in my case, the United States, the funder was liable for aiding and abetting the violation of a court order because the judge concluded that by funding this litigation process, knowing that it was in violation of the court order, the litigation funder had aided and abetted the process.
Can you describe how Garrett Kelleher actually invested in the case?
You know, we don't know that because I still haven't seen the funding agreement. All we know is that Martin Kenny introduced him to the process. Oh, we do know this. We do know that he invested through a Maltese SPV, which in turn invested in a BVI entity, which held the rights to receive the judgment. So that was part of the difficulty in finding out who he was. But the real difficulty was the refusal of anyone who knew who he was to tell us who he was.
I'm Philip Barney with Higgs & Johnson in Grand Cayman. I'm just interested on that cost point. I think what you said was that the attorney was liable and a cost order was made against him. Can you tell me, was that a wasted cost order under GCR Order 62? Is that what we're talking about here? In other words, because that's something which the court can impose of its own volition if it believes that an attorney has in some way behaved incompetently. I was just wondering if that was the basis of the order, because the gentleman in the front asked quite a good question about, why would the attorney be liable in those circumstances? And that's the only thing which occurs to me. One other thing is that the company, according to Google, Economist, he was the mythological king of Arcadia.
Well, I have to confess that I'm an amateur at Cayman law. My understanding, it was not a wasted cost order, that he was liable because this was a nominal plaintiff, and he was effectively controlling it under the Icarian reefer case. There was an issue about whether the court had jurisdiction to serve out on Kenny. He is not a resident of the Cayman Islands, he's a BVI resident. And this is an issue that I think is only a matter of Cayman procedural law, but we prevailed in the Cayman trial court on that. Kenny took us all the way up. We prevailed in the Court of Appeals, and the Privy Council declined to hear the case. So where matters stood was that the court found that there was jurisdiction over him because he was likely to be liable for the costs, and at that point he settled.
I think, too, it's interesting the nature of the questions. You have to keep in mind that there's two paradigms here, right? There's the paradigm where you have a legitimate piece of litigation that someone's funding, and how much are they on the hook for costs, fees, or other damages. Then you have a fraudulent scheme or an extortion scheme or any other kind of criminal enterprise that's using litigation as the vehicle to extort or commit the fraud. And in that case, anybody who participates can be liable for the damage done to the person who's having the crime or fraudulent acts committed against them. So that could really change the nature of the litigation funder or anybody else's liability who participates in the scheme. So you want to take us to the next case?
Sure.
I still had a question, if that's all right.
It's hard to see, sorry.
That's fine. But as a liquidated trustee receiver operating from outside of the U.S., I've run into this problem in the past where a U.S. court extends jurisdiction on a global basis, and I have no idea or understanding how they get that right. I mean, glory be, if someone's an officer of another court, acting on direction from an officer of another court, with instruction to act outside of the U.S., I mean, how does that really bite, other than the fact you can be mean and nasty?
The jurisdiction in this case arises from the violation, the knowing violation of a U.S. court order.
Yeah, but where does the U.S. court get to say where I bring my actions if I'm an officer of another court or acting on instruction from an officer of another court? I just don't get that.
Yeah, there is, there's an interesting question here which has also come up in the Argentina case, which probably most of us are familiar with now, about the extent of the powers of a U.S. court to exercise jurisdiction over foreign parties who violate its orders. We were always very careful to litigate in a way that distinguished our case from the situation in the Argentine case where the trial court had purported to order foreign banks not to dispense Argentina's money to pay off bonds. That was never tested on the Second Circuit. I wouldn't have been surprised if that was held to be, to exceed the authority of the district court. But in our case, we had individuals who knowingly pursued this path. We decided at the end of the day not to pursue the receiver, in part because it raised issues of sovereign immunity. We took a trip to the Third Circuit at one point on sovereign immunity issues also, which was resolved inconclusively. But I would think that acting for a foreign government, you would at least have immunity issues that you could raise.
I'm going to follow up on that. Let's flip the facts a little bit. Assume we're an American firm, and we're trying to seek justice for our clients, whoever they are, and the other side is able to go to a court in some other country, let's say Iran, and get an injunction against that conduct, believing fully that that was, let's just say, problematically obtained. Are you supposing, by virtue of the argument you're making with regard to this application of the jurisdiction by violation of the U.S. order, that the American firm or the American lawyer seeking justice for his clients in, say, Iceland, would be barred because of this Iranian injunction? Because that's exactly the facts, the way I see it, that you're proposing. So we as American lawyers would be shut down from seeking justice because somebody went to another place and obtained an injunction. Now, I take on board, this is the federal district judge in Philadelphia, That doesn't mean he doesn't make a mistake,
Well,
or worse.
I think the hypo that you said suggested that the U.S. lawyer would be barred in a third country from proceeding. I don't think that's the case. I mean, there was certainly nothing stopping Martin Kenny and other lawyers from acting on behalf of AJA or the receiver in the Cayman Islands. But the effect of an injunction, is extant in the country that issues it. In our case, the Liberian court at one point issued an anti-suit injunction. And I'm fairly confident that I'm in violation of that anti-suit injunction, and Liberia is not part of my travel plans for the near future. If
that's really the case, if it's about travel plans, then we're going to have to be very careful about where we travel to the extent we are seeking justice in multiple jurisdictions, because maybe I'd misunderstand the facts. Was Mr. Kenny seeking to posit or bring litigation in the United States?
No, he wasn't.
So where was he bringing this litigation that would be violative of the U.S. injunction?
In the Cayman Islands.
Okay, so it is a third country. So how is that any different if you flip it around from what I was just saying? Because I'm very concerned about how this would affect me as an American lawyer who's asset recovery lawyer that is dealing with multi-jurisdictional cases where someone could go out and procure an injunction, even frankly, and I'm going to use a legal term, bullshit injunction against me, like you suggest the one is against you, the anti-suit injunction, that would then be used to stop us from representing victims. That seems to be, we are headed toward a very ugly place if that's the case. And look, I'm an American, I love extraterritorial jurisdiction, but there's got to be at some point a limit to that.
Well, and I think there is. I mean, in each of these cases, you're going to have implications of jurisdiction and comedy are really going to be sort of your touchstones. And so, yes, you're going to get competing judgments from different jurisdictions, and the jurisdictions are going to have to sort that out. But I think it is right at the end of the day, there is some risk for the lawyers involved, and you have to evaluate that based on those principles. But it is a real concern. I don't think anybody should be dismissive of it.
Well, in the Chevron case, the Second Circuit limited the injunction. There was an injunction issued by the district court against enforcing a fraudulent foreign judgment, and the Second Circuit limited the effect of that injunction to the United States. And so, in fact, there are enforcement actions on that judgment pending in 3 different countries outside the U.S.
So we should go to the next case.
Yes.
Sure. I'm Roy Powell with the law firm of Jones Day, and with a group of lawyers in our Pittsburgh, London, and New York offices, we handled a case for Texas Keystone and Gulf Keystone, the co-defendant, filed by Excalibur Ventures. A little background. Post-Iraq II, Kurdistan province, which had never been allowed to develop its oil and gas reserves, began the process of looking to develop those oil and gas reserves. Little map. There was a field in northern Iraq that the Kurdistan regional government and the oil minister was looking to develop, and they do it through production sharing contracts. Is sort of the standard in many Middle Eastern countries, where you pay a fee to the government for the right to develop the oil field. There's a bidding process for that, and then you pay them a percentage of the revenue from the field while you're operating the field. Very speculative venture. Everybody thought there was oil in Kurdistan province, but because they had never been allowed to develop the oil fields under the Saddam regime, no one was quite sure. Our client, they're the parties. Excalibur Ventures was a claimant. It was founded by 2 brothers, Eric and Rex Wempen. Rex Wempen, colorful character, ex-Army Special Forces, allegedly a black ops operative in Iraq during Iraq II. His brother, an attorney who was actually employed by UBS in the United States. The defendants were a number of both domestic U.S. and international oil and gas development companies, some privately held, some publicly held. There was a collaboration agreement and then the bidding group agreement where Excalibur claimed in 2006 it was entitled to 30% of the interest in the oil field in northern Iraq. At the time of they filed the case in 2010 after, of course, a huge oil discovery in Kurdistan province within this area. They claimed that their interest in the field was worth at least $1.6 billion. enter the litigation funders. Excalibur initially filed an ICC arbitration in New York under an arbitration provision in one of the contracts, and then at the same time tried to get a worldwide freezing injunction for all of the assets on all of the companies, including the publicly traded one, in the court in London. To sort of go back to the jurisdictional question, that was the battle. Should it be fought in the ICC in New York in the US under US law? Should it be fought in the English courts under what became a multitude of different laws in the commercial court? The court determined under English law, and that principle would be accepted in the United States and certainly all English law countries. Once the plaintiff went to court in London, the plaintiff submitted itself to the jurisdiction of that court. And therefore, the court in London had the ability to enjoin the ICC arbitration. But it was based upon an actual act by the party submitting itself to jurisdiction, as opposed to an extraterritorial kind of exercise of jurisdiction. Anyway, the claims, they threw everything at the wall that you could possibly imagine. The case got quite a lot of publicity, especially in the UK, but also internationally. The case had so many components and so many different legal concepts that were in play. The court in London had to apply New York law, London law, the Kurdish oil law, which nobody quite understood. Texas law governed some of the issues. And the case proceeded for 57 days in court, in the commercial court, in the longest commercial trial that was tried in London in a decade. There were, I just like this cartoon, the difference between barristers and solicitors. Each side had a really high-level team of barristers that argued the cases with the solicitors behind them. Here's basically how litigation funding came into play. In the UK courts, there's a cost-shifting provision. Litigation funding has been prevalent in the UK long before I think it really came to the United States. And there's two types of litigation funding. One is pure funding. That is where a litigant could not pursue their claims, and in the interests of justice, a funder provides them funding with no ability to control the case and no real pecuniary gain on the back end. In that instance, the courts have, through rulings, have indicated they're not going to make that litigation funder put up security for the costs to the defendant in the event that the plaintiff is unsuccessful. And the rationale is it's in the interest of justice, and this plaintiff would not have access to justice without this. And then there is the commercial litigation funding, where the litigation funders are in it for the monetary gain. And that's litigation funding I know that was talked about in the group yesterday, where there's that self-interest. The court finally issued its opinion after 57 days of trial. The courtroom was twice as large as this room, and there was paper everywhere. The opinion itself went over 400 pages with exhibits that analyzed each and every one of the claims in the case. What was determined by the court was that they were going to award costs. By this time, the funders had put up almost $50 million US in security, actual cash, to support the litigation in terms of both paying Clifford Chance's reduced rate legal fees. The law firm had a contingency fee component, as well as posting security for costs. The difference in the UK is indemnity costs versus standard costs. Standard costs are about 70% of the defendant's costs. Indemnity costs go to 85% or even higher. Indemnity costs are kind of unusual, and they're awarded where the case lacks merit or because of the conduct of the lawyers. And in this case, the determination of the Court of Appeals was even though the funders lacked culpability, they were still on the hook. The other thing is, in the UK system, there's something known as the Arkin cap, which means the funder's liability is capped at the amount at which they contribute or fund the case. This case took that Arkin cap, and while it didn't completely reject it, what it said is the funder's liability was not just what they used to fund their lawyers, but it was also capped. You added to that any amounts that they posted for security for costs on top of it, which essentially caused the funders' exposures that were held to be jointly and severally liable to exceed the amount that they invested by quite a substantial amount, especially the ones that had not gone out of business by then. The court noted that of all the litigation funders that were in this case, that only one of them had ever had any prior experience in litigation funding. And that entity went bankrupt during the course of the litigation. So that the neophyte funders are the ones that really got left holding the bag in connection with the case. What did this mean? What did the court determine? A, there didn't need to be any act of bad faith. B, that the funders failed to scrutinize the merits of the case. Their claim was Clifford Chance, one of the largest law firms in the world. The case was being run by the head of litigation for the entire firm. He told them it was the best case he'd ever seen with a 90% chance of recovery. The court determined that he had an inherent conflict of interest that did not allow him to be unbiased because the firm had invested in the case itself through its contingency fee agreement. What the court determined is that these funders needed to conduct their own due diligence throughout the course of litigation, not just on the day that they put the initial funding in, but at every point in the case where they added additional funds, where the funding agreements changed, they had their own duty. The argument on just the funding issue, on who would be liable and for how much, the judge gave the parties 3 days of argument, 8 hours a day. The Association of Litigation Funders that exists in the UK, because their system has been around, they intervened in the case because they thought it was important and frankly refused to defend the conduct of the funders in this case, but wanted to make sure that the arc and cap was not modified as the court eventually did do it. The court determined after the 15 days of trial, in its opinion, that the case was objectively hopeless, despite the opinion of the head of litigation of a very large law firm that it was. What the court determined is that the funders needed to engage separate counsel to give them their own legal opinion in order for them not to be held liable jointly and severally and on an indemnity basis. Clifford Chance's deal was they got 140% of their usual fees, and that the funders were aware at every step of the contingency. The court, in describing the funding agreement, it took 12 pages because there were so many tranches of funding from so many different funders. The first funder was entitled to 21% of the total recovery in the case with an investment of $12 million. I'm sorry, 12 million British pounds. So their upside was in the 300 to 400 million range, significant upsides in the case.
How much was even left for the claimants in that case? Because if Clifford Chance also was on contingency with a 40% bonus.
The claimants, the court analyzed what the claimants were likely to recover if they recovered $1.6 billion and said that the claimants would end up with around 50% of the recovery. Interestingly, the court also found after the trial that the maximum recovery, because if there was a breach of contract, the damages were measured at the date of the breach when there was no oil discovered, that the max recovery would have been $3.3 million, even if they were successful in the case. So a big error of law in terms of the analysis as to when you measure the breach damages. This is some of the quotes. The justice on the appellate court said that Excalibur's counsel claimed that it was the best case he'd ever seen in his career and gave it an estimated success of 90%. And it was because of the partial contingency that Clifford Chance themselves had from the outset an acute conflict of interest, the extent of which worsened as their own investment in the case increased over time. It should have been obvious to any astute businessman. The court held that a responsible funder must conduct a rigorous analysis of the law, the facts, the witnesses, and proportionality issues at appropriate intervals and not just at the outset of the case. So the takeaway, to summarize, is that litigation funding is very different in English law jurisdictions where they've got to post not only fund their lawyers, but post for security for costs on the other side. In the UK and Australia, very prevalent. And what this case really did from a funding perspective is put much more of a burden on the funders to get outside independent counsel evaluation of the case, to stay involved in evaluating it in terms of making their funding decisions where their liability can be greatly increased.
Did any of the funders try to structurally protect against a liability finding in terms of a corporate structure so that their exposure was limited, and did that work?
Yeah, in this case, one of the funders, Platinum Partners Value Arbitrage Fund, LLC, a New York-based litigation funding group, created throughout the case 4 special purpose vehicle, 99% or more owned by Platinum Partners, and each vehicle was funded with just enough money to fund the litigation. So they were effectively judgment-proof the day they funded the litigation and therefore couldn't be held responsible. What the court determined is that they couldn't hide behind that and basically made the liability not only joint and several, but had it go all the way up to the parent Platinum Litigation Funder entity, which recently is declared bankruptcy and insolvency, I guess, in the Caymans, and the principals have all been indicted in federal court in New York for running a Ponzi scheme with their investors in their litigation fund. Didn't turn out too well for those guys either.
Question. We are constantly told that litigation funders don't control the case, that once that litigation fund agreement is entered into, they must run through, subject to the exit strategies in the agreement, but they don't control the case. Therefore, I'm coming to not understand how the litigation funder can regularly, after the agreement is signed, regularly do its measurement and analysis of the case. To what purpose if they don't control the case?
So that's a great question, because under English law, champetry is not legal. So they can't control the case legally. And the court walked a balance between those two things and say, to close your eyes completely and not do any independent evaluation and then say you can be off the hook for liability isn't going to fly. The court also recognized that this due diligence or evaluation of the case at appropriate steps along the way when additional funding is required is absolutely required. And that you cannot merely rely upon the opinion of the lawyers that are representing the named plaintiff in the case, especially where they have a conflict of interest. So the opinion recognized that issue very clearly, and again, the Association of Litigation Funders, that was the primary basis on which they intervened, in addition to defending the Arkin cap, because they were looking for some clarity as to where that line is. And I think the court did a really good job of analyzing that it wasn't saying you can control the litigation, but you can control your decision to continue to fund the litigation and invest money in it.
So the only option then for the funders was to walk away. They didn't have control in any other sense, right?
And that's correct. And in this case, at one point, when the trial continued and the judge, there was a hearing on additional security for cost because the trial was originally contemplated the last 2 weeks. And when the judge ordered additional security for cost in a significant amount, I think it was a 12 million pound additional security, the plaintiff didn't have the money. The funders had to either come up with it or decide not to continue the case. They asked for a 3-week recess while the funders apparently conducted internal negotiation as to whether to fund, who would fund the next tranches, and how they would modify the intercreditor agreements between them to split the award when it was done. It may be noteworthy, Clifford Chance was sued for malpractice at the conclusion of the case by one of the funders. The case files are sealed. It was publicly disclosed that they settled it. Who knows for what exactly that was, but that decision was, the decision as to whether to additionally fund was not viewed as champetry by the courts at all.
Okay, I can't see any more questions, so we're going to move on to Chevron versus Donziger.
Can I have the clicker?
Oh, yes.
So many of you may have read about this case before. It did get enormous amounts of press. We at Gibson Dunn had the privilege to represent Chevron in combating a fraudulent Ecuadorian judgment. And we were able to bring ultimately a successful civil racketeering case against the lead American lawyer behind that case, Stephen Donziger. And the court noted in that opinion that justice is not served by injustice, and that there is no Robin Hood defense to wrongdoing. And I think that this is a good lesson for deceptive attorneys who wish to pursue fraudulent claims. So just to give you a little background about the dispute, sorry about that. Chevron was involved only because it acquired Texaco after Texaco had been involved through a subsidiary in a joint venture, essentially, with the government of Ecuador to drill for oil in part of the Ecuadorian Amazon, this area called the concession area. When that joint venture ended, TexPet, which was the name of the subsidiary in Ecuador, negotiated a settlement and release with the Ecuadorian government and the state-owned oil company. It ultimately remediated a portion of the sites in that area that corresponded to its interest in the joint venture, which was approximately 30%. Now, Chevron was sued in Ecuador over environmental liabilities allegedly related to this in 2003. Chevron's position from the beginning of the case, of course, was that it was not even properly a party, because even though it had acquired Texaco, Texaco was still a separate company, as was TexPet, the Ecuadorian subsidiary. But it was forced to defend itself in this case, and after a few years of litigation, it began to strongly suspect fraud. And that's where we came into the picture. So in 2008, you have a court-appointed, essentially a damages special master who's supposed to be neutral and is the only expert that's authorized to provide a damages opinion to the Ecuadorian court, this gentleman, Richard Cabrera, and he's telling the court that Chevron should be liable for $27 billion worth of damages. And he's swearing up and down to the court that he's independent, that he hasn't been working with the plaintiffs, and the plaintiffs are saying the same thing to the Ecuadorian court. You have an American lawyer that is promoting this suit that, even though he is not qualified to practice in Ecuador, is definitely the lead lawyer on this case. And he's engaging not only is he orchestrating what happens in the Ecuadorian proceedings, but he's engaging in what was found by the Southern District of New York to effectively be an extortionate pressure campaign in the U.S. He's testifying before Congress, telling Congress how, this special court-appointed neutral special master has told the Ecuadorian court that Chevron is liable for billions of dollars in damages. He's also cooperating with U.S.-based NGOs. One in particular was Amazon Watch, and these NGOs are writing to the SEC and other governmental entities, the New York Attorney General, trying to spur investigations of Chevron, largely based on its purported failure to disclose this liability adequately in its securities filings. And this is a slide I've had for a long time, but I recently changed the name because I think it's appropriate. Essentially, there was a fake news campaign against Chevron where you would have these outlets that were all interconnected and all effectively controlled by the same people who would publish and republish these lies effectively about Chevron, and it was just propagating them across the internet. So where do we come in? We came in about 2009, and Andrea mentioned earlier 28 USC 1782, which is a statute that allows you to take discovery in aid of foreign proceedings. So Chevron suspected fraud. How are we going to get evidence of it? We weren't going to be able to get it in Ecuador, but here you have a case where there's a very strong U.S. component, and effectively a case that, even though it's in Ecuador, is being controlled from the U.S. So we started seeking that discovery, and we went on little clues like this, where there was an expert report filed with the Ecuadorian court where the expert's name was misspelled. And we filed a 1782, we deposed him, and indeed he told us that he had not written the report, that the reports were fraudulent, that the conclusions did not match his conclusions, and that effectively the plaintiffs had taken signature pages that he had provided them. We've all done that before, have the expert send you the signature page, and then they'd filed reports that he had not in fact written.
And the distinction here was this was one of their environmental experts. So in the report that was filed with the court, he made findings of rampant contamination, harm to human health, harm to the environment, millions and millions of dollars, tens of millions of dollars at each site in damage. In the report he actually wrote, he reached the conclusion that no further remediation was required. There was no risk to human health or the environment. So it's definitely a night and day situation. It wasn't a tweaking of the report.
And significantly, this expert was a party expert, just like we would have in the U.S. He was hired by the plaintiffs, so it was not a situation where he was a court neutral. Another thing was that we suspected that a Colorado environmental consulting firm had been involved in the court-appointed expert's report. So we sought discovery from that entity, Stratus, and that discovery, which we later got a peek behind the scenes of what was going on during that Stratus 1782 proceeding, and which was a months-long effort to obstruct it, to avoid producing the discovery. But ultimately we did get it, and it showed that Stratus had in fact written the Cabrera report from top to bottom. Its involvement was never disclosed, and it had in fact written the entire report, and Cabrera had simply filed it. He had really nothing to do with the content of the report. So then we went after some outtakes. There was a documentary film that was promoted by Donziger about the case called Crude. And we wanted to get the outtakes from this documentary. They had cameras, the plaintiff's team had cameras following them around for years. We wanted those outtakes. And fortunately, some members of our team noticed that by coincidence, they decided to watch the Netflix version of the movie. And they had been watching a DVD version over and over again. Because they had seen that so many times, they were actually able to identify in the Netflix version that a scene had been cut. The picture on the left includes a member of Cabrera's team, and this is a meeting with the plaintiff's team. So this scene, same audio, but they had removed that video and replaced it with what you see on the right. And so using that tiny piece of evidence, we were able to get all 600 hours of the outtakes of this film, which proved to be, really, they broke open the case. And meanwhile, what's going on the plaintiff's side of the case is that you have the longtime funder of the case, Joseph Cohn, a Philadelphia plaintiff's attorney, who had funded it as a normal contingency fee case. He had, I think, spent about $7 million on the case. And so as this stuff is starting to trickle out in U.S. courts, he himself is aghast. He did not know that Donziger was orchestrating these frauds before the Ecuadorian court. And he's starting to say, look, you've got to give me more control over the case or I can't fund it anymore. And so because Donziger knows what's going to come out in these discovery proceedings, he starts looking around for more funding. And before really the bulk of the evidence came out, they entered into a funding agreement with Burford. And Burford invested in tranches. The first tranche was funded, and shortly after that tranche was funded, you start to see this evidence emerge into public view. And Burford ultimately terminated its funding agreement, but the plaintiffs were nonetheless able to get more funding from other institutional funders, as well as, similar to your case, a wealthy individual who either saw a cause he liked or just an opportunity to make money. So right around the time Burford invests, these outtakes start to come out. So the outtakes included hours and hours of footage of an elaborate planning meeting with the court-appointed neutral damages expert. This meeting took place before he was even appointed by the court. So the plaintiffs knew the court was going to appoint him because, in fact, they had effectively extorted the judge and blackmailed the judge to force him to appoint Richard Cabrera. And they held a planning meeting where they, along with their environmental consultants from Stratus and other entities in the U.S., all went to this big planning meeting to plan the global assessment. You'll see the letters behind Cabrera is there in the middle in the Mets colors. And you'll see that the slide behind him says, the plan for the global expert examination. So the clip I'm about to show you, you'll see that it has subtitles. It is in Spanish, but you'll see the lead Ecuadorian lawyer for the plaintiffs, Pablo Fajardo, at the front of the room. going through how they're going to put together this expert report. And then it'll go to the audience, and you'll see someone who, one of the strata scientists, Ann Maced, and you'll see her comments.
Vean, la carga no va a ser del perito. La carga la llevamos entre todos. Y queremos el compromiso de todos para este proceso.
Tengo una pregunta. El informe final, ella dice, el informe final va a estar elaborado solamente por el perito.
El perito lo que va a hacer es dar su criterio, ¿sí? Y firmar el informe y revisarlo ante eso. Pero nosotros, entre todos, tenemos que aportar en ese informe. Juntos. ¿Sí?
Pero no, Chevron no.
But not
So needless to say, these outtakes really broke open the case because there's just something about seeing is believing, right? And this next clip I'm going to show you takes place also they're at lunch during this meeting with the supposedly neutral damages expert. And it is Donziger, you'll see him on the right, with a couple of scientists who had been at the meeting. And here you'll hear Donziger's, basically his theory of evidence.
What we know about groundwater contamination, the extent of contamination. We don't have that.
And right now, all the reports are saying it's just at the pits and the stations, and nothing has spread anywhere at all.
That's not true. That's not exactly true.
The reports are saying that it's groundwater contaminated because we've taken samples from groundwater.
That's just right under the pits.
Yeah, but that is evidence.
Mm-hmm. Well, you need
one thing I visually see. No, I agree.
Just right.
But hold on a second. You know, this is Ecuador. Okay, you can say whatever you want. In the end of the day, there's 1,000 people around the courthouse. You're going to get what you want. Sorry, but it's true. Okay. Therefore, if we take our existing evidence on groundwater contamination, which admittedly is right below the source, and wanted to extrapolate based on nothing other than our theory that it is. We average out to going 300 meters in a radius, depending on what do you call it when the land goes down? The incline. You know what I mean?
Gradient.
We can do it. The gradient. We can do it, and we can get money for it. And if we had no more money to do more work, we would do it. You know what I'm saying? Yeah. And it wouldn't really matter that much, because at the end of the day, this is all for the court, just a bunch of smoke and mirrors and bullshit. It really is. We have enough to get money to win.
So, I mean, just to add a little bit to what Annie was saying about the power of the video, we ended up being in over 34 U.S. courts on behalf of Chevron in connection with the Ecuador case, mainly in 1782 proceedings, because the fraud was orchestrated from the U.S., so many of the participants were here. And I can tell you that when you show these videos to a judge, their whole demeanor changes. They found it as shocking as you would expect them to do, and the other side just could never recover from the power of the smoke and the mirrors and the bullshit type quotes.
Well, and you might ask yourself who would be dumb enough to let a camera crew follow them around and film all this stuff. And I think, you know, there's two things here. One is that actually from this same lunch, there's an outtake that shows Donziger telling them to turn off the cameras. And I think part of it was that he felt comfortable that he had editorial control over what was ultimately issued in this movie, and that was proven to be very true later. The scene that I showed you, that they had changed the video under it in order to avoid showing that they were in a meeting with a member of Cabrera's team. They begged the filmmaker, that early cut was released in a festival, and the plaintiff's lawyers saw it, and they begged the filmmaker, Joseph Berlinger, to take it out, and they told him, you could destroy the case if you let this get issued. And so what was issued on the DVD had replaced that scene. So they really did have editorial control over this movie. I think the second thing is the classic, you know, what happens in Ecuador stays in Ecuador. I think that they believed that, and, you know, we were able to use 1782 to show that that definitely was not the case, and they just never thought we could do it, as you'll see from a clip I'll show you in a moment. This next clip is Donziger providing his unvarnished opinion about the Ecuadorian judiciary.
All the judges here are corrupt.
They're all corrupt. It's their birthright to be corrupt. Why? Because they get paid so little.
You know,
it's the culture. It's disgusting.
This is problematic for them because, among other things, if you're trying to enforce a foreign judgment in the U.S., the impartiality of the judiciary where that judgment was rendered matters, right? And there's many clips where Donziger's talking about how corrupt the Ecuadorian judiciary is. So this next video, this is a very short clip, but you'll see why I included it. And it's a group of people, including people from Amazon Watch, Atosa Soltani, Luis Yanza, the gentleman you see on the screen, who is a non-lawyer representative for the Ecuadorian plaintiffs, and Donziger. And they're all sitting around in the room. And you may remember Donziger saying in that last clip about smoke and mirrors about how if we surround the courthouse with people, we're going to win, right? Well, similarly, in this conversation, they're talking about how we need to raise a private army to surround the courthouse. And Atosa Soltani is a little bit disturbed by that, and you'll see you'll see how the team responds.
Ustedes saben que si alguien puede subpoena estos videos, que es una, ¿cómo se dice? What about US, these guys?
Un ejército, no es un ejército armado, es un grupo de gente para vigilar la corte.
I just want you to know that it's illegal to conspire to break the law.
Again, the hubris is incredible. This is another email we were later able to obtain from Donziger in 1782 discovery. And this email is actually from one of his Ecuadorian team members about the Stratus Colorado discovery proceeding, where he emailed Donziger in the middle of that proceeding saying, if this evidence gets out, we could all go to jail. So needless to say, this evidence was explosive, and we filed a RICO complaint on February 1st, 2011. A couple of weeks later, the Ecuadorian court did issue its judgment in the amount of $9 billion, which it ordered to be doubled if Chevron did not apologize. Needless to say, Chevron did not apologize. Burford refused to fund further, we later found out, after the court issued an injunction, among other reasons, including the fraud evidence that was emerging. After the Ecuadorian judgment was issued, we discovered even more explosive evidence of fraud, which was that because we had obtained all this discovery, you'll see this highlights. These are overlapping passages between documents we had obtained in discovery, documents that were never submitted to the Ecuadorian court, and the Ecuadorian judgment itself. Pages and pages of overlap. Things that can't be explained either. You know, we're talking about misspellings even that were copied into the judgment. It was ultimately, what, 11 documents?
Yeah, and internal memos in their entirety pretty much showed up in the judgment.
So it was clear that the plaintiffs had in fact ghostwritten this judgment, or at least controlled the drafting of this judgment. So we ultimately went to trial in the RICO case in 2013. The court found that Donziger had orchestrated a racketeering scheme, including fraud, violations of the Foreign Corrupt Practices Act through the bribery of the court-appointed expert, Richard Cabrera, extortion, money laundering, witness tampering, obstruction. And so, you know, to bring it back to the topic at hand, you know, I think one thing that's interesting about this case, as well as some of the other cases you've heard about today, is that there are a variety of sources of funding, right? You've got your sort of traditional plaintiff's lawyer working on a contingency fee who funded the case for many years. And then you have the gentleman second from the left, Russell De Leon, who was an old friend of Donziger's and had a lot of money. He made a lot of money in internet gambling. And he ultimately was the biggest funder in the case that we are aware of. He paid over $25 million into the case over time. I think he was also a producer on Crude. He helped fund the documentary film. And then you have Burford, who was involved really for a relatively short time, because shortly after they funded, the Crude outtakes came out, some of the evidence from the Donziger 1782 came out, and they terminated the funding agreement. So Burford was really only involved, all told, for about a year or less. And then you have another litigation funder, Woodsford, who comes in only 6 months before the RICO trial. So by this time, there is massive amounts of fraud in the public record, available to anyone who looked at it. Nonetheless, Woodsford decided that the chance to enforce an $18 billion foreign judgment was worth the risk, and they invested $2.5 million in the case in just about 6 months before the RICO trial.
The other funder, from the contingency fee standpoint, was Patton Boggs. They stepped in after Cohn stepped out, and it was sort of on the basis, as the testimony unfolded in the RICO trial, a lot of the reason that a fund like Burford got comfortable with the case was because Patton Boggs was involved and they were reputable. So they didn't do as much of their own diligence as they might have otherwise if a firm of that stature hadn't been involved. On the back end, however, all of the funders ended up settling with Chevron, releasing all their interest in the judgment, and Patton Boggs actually paid Chevron $15 million. So
I think it was 10. Was it 10? Was it 10? I don't remember. 10 or 15.
But the point is that, again, you have a funder, although in the form of a contingency fee counsel, who, because they're participating in the bad acts, is ultimately on the hook financially. So you really have to pay attention to the nature of the underlying action in which you're investing, because it's one thing to say, well, I didn't evaluate the case right, it was a loser, not a winner. It's a different thing to say, oh, I didn't realize it was a fraudulent extortion scheme, because that's going to be much more of a problem.
Well, and I will say, though, that I think this case really illustrates how far you can go with bald-faced deception, right? Where you've got one guy at the middle of it, Steven Donziger. Certainly he had help from a lot of people, but really he was at the center of it, orchestrating this fraud and really able to fool multiple people, multiple courts, multiple organizations over time about the nature of this case. And I think that this case underlines the importance of the diligence process in funding. You know, it's hard to say what could have prevented this, but certainly I think had the funder or Patton Boggs demanded more unfettered access into, for example, Donziger's own documents, rather than taking his word for what happened, that would have helped.
I was at the part of the conference yesterday where there were some funders actually describing it, and one of them used the analogy of, in terms of picking cases, they pick the jockey, that is the lawyer who's going to push the case because they've got a vested interest in it. And at first blush, that makes a lot of sense. But the reality is, in these two cases, you've got two very large and well-respected law firms that took a contingency fee position in a case, and the funders said, in my case, absolutely, that was the most important thing to them, and tried to avoid further liability based upon that fact. And what the court said is that's not enough, that you need to get some independence and a second opinion if you're going to walk away from the liability. And, you know, we're all lawyers. It's sort of hard to criticize our own profession. But at the end of the day, when the lawyers take that big case on a contingency fee basis, as the court determined, they have an inherent conflict of interest, and it's something to be careful about.
Are there more questions?
Go. Oh, sorry.
Hi, this is Gary Miller. Excuse me. I represent Martin Kenny in the Liberian case. I'm going to be speaking about that case at 1:30. In case you're not able to make that, where I'm going to give a little bit of a different perspective than Mr. Hawthorne, I want to just make two comments. The first is, I think it's a little bit regrettable that our case was put with these other two, and I just want to make it clear no one comes away with a wrong impression because of the way these were coupled. In our case, there's no, I think Mr. Hawthorne would agree with this, there's no allegation of fraud by anybody. There's no allegation of misconduct by anybody. There's no Ponzi scheme involved. There's no allegation that the Liberian court was corrupt. It's a legitimate good faith dispute over conflicting judgments by two courts that are to be afforded equal dignity. So I'm kind of sad that these cases were put together because that might lead to the wrong impression. Second point, I think Mr. Hawthorne misspoke, and I'm sure it was unintentional. There was no finding in the Cayman Islands that Mr. Kenny controlled the litigation. That was the theory of liability to hold him liable for cost, but that question was never litigated. The only question that was litigated was jurisdiction, and then there was a settlement before the question was litigated.
I'm not going to respond to all those things because I don't want to turn this into a personal debate. I will just correct the last point. In order to find jurisdiction, there was a preliminary finding that there was a good arguable case, and the court said more likely than not that we would be able to show that Kenny would be liable for fees because he did control the case. And perhaps you weren't on board at that point. But
I actually kind of agree with that last comment a little bit. I think there is, you kind of have to unpack these three examples because they are very, each of them are interesting in their own way. The first one, I mean, when it ultimately gets decided, and I said it earlier, I used a phrase, I said, the judge could be wrong or worse. By or worse, I meant that a court could be led to error. And it may ultimately be determined in that case that this is just a very powerful litigant using litigation for retribution. So we have to keep our eyes open and wait and see how that ultimately shakes out. The other two, I think, really do go more, that first case doesn't seem to be a funding issue as much as an issue of battles between jurisdictions. The second two, I think, really raise serious questions about the natural tension between how do you as a funder, and we have a lot of cases that are funded, monitor the case, but still remain independent and not controlling the case. It's very difficult because we all know as lawyers, there are lots of decisions made, sometimes 10 or 20 a day on whether you call a witness or what you do or what piece of evidence you touch or don't touch. I think it's very important that we not create a burden on funding to monitor this as they go along, because ultimately this turns to an access to justice issue. There are many, many moneyed interests in this country and others that would love to kill litigation funding. They want it dead. They want it dead because it levels the playing field, a tilted playing field. And so it allows claims that are otherwise very good claims that can't be brought because there isn't money in it, or essentially the little guy from bringing the claim. And for example, the United States Chamber of Commerce is very much against litigation funding. It has made it very clear. So I think we have to be careful that as we work through these growing pains, and they may just be growing pains, we don't start to force funders to make all kinds of determinations at the outset and at the very beginning, I mean, and as you go along, that essentially force them to be in control anyway. So I don't have an answer for that, but I do think that we have to be very careful because we are in, you know, I think yesterday in the panel it was described as the first day or first year of well, now we're into the second year, and I'd love to hear the panel's thoughts on how you would suggest this ongoing monitoring, and obviously some of this stuff is public, so the funder's going to see it, but what about the stuff that's not public until it bursts onto the scene? How is the funder going to react to that but not be in control?
Well, I think just to take the flip side of what you said, it is important that everybody have access to justice, absolutely, and that often does require funds, as we all know. On the other hand, I don't think you can provide funding for an enterprise and then claim you've turned a blind eye to the whole situation. And you know, whether the enterprise is litigation or whether the enterprise is something else, you know, you have to take some level of responsibility. So I think probably the paradigm is closest to insurers, right? They never want to take control of a litigation where there's a dispute as to coverage, but they still monitor it and they still make decisions about whether to settle, whether to continue. So there's a lot of cases in which the parties from whom the funds come participate enough to make reasoned decisions about their own actions, at least, regardless of whether they control the actions of other people.
Let me just push back on that. If my client goes out to a bank and gets a $2 million loan from First Union or Wells Fargo and uses that $2 million to fund their case, is the bank liable if the lawyers engage in some sort of skullduggery or chicanery? It's a loan. It's a loan. So it really comes down to how are you? Not
to interrupt you, but I think that's a very inapt analogy because the bank doesn't have an upside, right? The bank is getting its 5% or its 2% or, you know, it's 10%, whatever the going rate is. It's just loaning the money. It's getting its interest regardless of whether you win, lose, or draw. If you have an upside, it's different.
Yes, and I just to make a couple observations, I think that the established institutional funders have demonstrated their ability to respond, I think, appropriately to cases when they're going off the rails and have walked away from investments and ceased funding. We've heard stories about that today in several cases. And I would also say that in case selection, Certainly in my case, I think that some of the people along the way made poor decisions because they didn't adequately think about the fact that they were ultimately funding a party who would voluntarily come to the U.S. and lost, and then got a judgment in another jurisdiction, which the U.S. State Department has continually said is subject to corruption in its courts. And indeed, these, as I've said before, we know that the funders and the attorneys expected some degree of censure and some degree of sanctions in the U.S. court, took on that risk and went ahead anyway. And I think that was a poor decision.
Yeah, and let me first of all, I agree with the comment. The Association of Litigation Funding of England and Wales weighed in as an amicus, and they raised the precise issue that you identified. And the court, in its opinion, and if somebody wants to give me their card, I'll be happy to send the opinion. It's very readable, very understandable, analyzed that push-pull, and recognized that it was important for litigants to have access to funding, but put on the funders where they're commercial funders. And again, you've got a funder who's got an upside of, on a $12 million investment, $300 million, said, when you're playing in that game, you better pay attention. And that was really the point of the analysis. But I think it's a really fair description, and I think maybe the UK system is a little further along than we are in the US in terms of trying to get some standards and practical approaches in terms of dealing with litigation funding.
One more question, then we're probably out of time.
Sure. My name is Derek Ho. I'm a partner at Kellogg Hansen. I represented Burford in the Chevron case and Ecomus in the AJA case. It seems to me that it is potentially fair to say that litigation funders could do more due diligence, and by doing more due diligence, do more to stop, rogue lawyers from doing bad things. But I think it's also important to point out that defendants who are often antagonistic toward litigation funding are themselves making it harder for funders to do that very due diligence by invoking doctrines like champerty and maintenance as bases to say that the funder can not do much to control the litigation, and by trying, as part of what I perceive to be sort of the defense side playbook, trying to pierce the attorney-client privilege and the work product doctrine and use discovery into communications between the litigation funder and the party as a way essentially to increase the cost of litigation. So if we want to be facilitating further due diligence, I think we also ought to be considering whether it's an appropriate tactic to be invoking these defensive doctrines as a way to impede that very thing.
I mean, I think that I don't disagree with really any of what you're saying, but I think that at the end of the day, defendants, in particular in contingency fee plaintiff type litigation, are going to continue to try to seek discovery about funding and with respect to funders, because often it's the only source of real discovery that they have. Often the plaintiffs don't have anything to produce, right? And so I think that's one issue, and the balance will be found by the courts, right? I think work product has largely been extended over funding related communications. However, not all of those communications are going to be work product. They may be purely about financial issues, right? So again, I think the courts are still finding an appropriate balance. I don't think it's a completely settled landscape. But I think defendants are going to continue to push their advantage, and plaintiffs are going to continue to push their advantage. And I think that the doctrines that we have about work product and attorney-client privilege are sufficient to address that. Champerty, I'd be interested to talk to you more about that, frankly, because it just seems like it's either a dead letter or it's not, right? Like, it seems like in many jurisdictions it really has almost no meaning anymore. And in other jurisdictions, it actually does. And I think that I think that the landscape in the U.S. at least is a little bit uncertain for funders in that regard, because you've got 50 states all with their different champerty laws.
Well, hold on a minute. I think these are bad cases, and bad cases make bad law. Right?
Fair enough.
That's the problem. It's too extreme. If you are a reputable funder, the first person you're going to go and talk to is the plaintiff's lawyer and see what their assessment of the chances are. Now, plaintiff's lawyers sign opinions on these things. Most of us are very careful about it. Some of it's going to go wrong. But once you start, never mind all these big cases, for the person who actually wants to go out and get a small case, which is important to them, funded, once you start to jack up the burden on the funder by taking out the degree of reliance that they can place on reputable counsel, reputable lawyers, and the rest of it, the whole litigation funding thing is starting to fall down because you just make it too cumbersome and too expensive.
They seem to be doing fine.
Well, no, it's not true. That is absolutely not true. I still act for small people, right? It's not funny for them, and this sort of thing is going to trickle down and it's going to make it harder for them. You try getting man-in-the-street funding because they're not big enough to make money for everybody and so on and so forth, and then you add another layer of complexity and some wasted cost orders and so on and so forth, and we're back to the bad old days, and it hasn't worked. So just never mind all these big cases, just look at the reality for the smaller punter.
May I just say one quick thing? I just want to remind everybody, I am one of those small people, and there is no justice where there is injustice with attorneys or with corporations. And you guys may be talking about huge amounts of money, but for someone like myself, when there's injustice with an attorney and I can't take action against that attorney, I think the larger conversation that everyone should be having is zealous attorneys versus overzealous attorneys. And when you're someone like myself with a lack of funding, I face overzealous Rambo attorneys all the time who are trying to shut me down. And so I think the larger conversation is, as each of you sign discovery documents and what you're producing or not producing, that you are honoring your oath as an attorney and that you're searching for everything that could be relevant to your case. So I just think it's a larger conversation.
I think that's right, and I mean, ultimately it's on all of us to do the right thing, and in the context of the funder situation, I think in both of these cases on this end of the table, you know, in our case, when Burford, for example, found out what was going on, they said they did the right thing. They said, we don't want to be part of this, we're out. The funders in Roy's case went in another direction, and they sort of had to pay the price for that. So whenever you do the diligence, or whenever the information comes to you as a funder or otherwise, you have to make the decision whether your continued involvement makes sense and sort of meets your do the right thing meter. And hopefully if it doesn't meet that, you will exit.
Again, I think there's also a difference between defending an ordinary litigation and defending a fraud, right? I think the type of discovery that you need in the latter case is different in nature. And there's going to be times when discovery about who a funder is or about the funding relationship is going to be relevant. But in the run-of-the-mill case, it's probably not going to be relevant.
Yeah, one last point, and again, I'm focused on the analysis that the court did in London in the case. The appellate court decision is 40 pages long. They recognized a word that appears over and over is proportionality. The amount of diligence that the funder needs to do is proportional to the size of the case, the amount they've invested, and the burden that they're creating on the other side. And you're dealing with a cost-shifting jurisdiction, so it's a little bit of a different animal because of that, because they didn't find fraud. That was not the point of the analysis at all. And the question is, again, in the smaller case, I don't think courts are going to hold funders liable for some broad due diligence in a case where they've got a minimal investment. But when you look behind the funders in this case, most of the principals were investment bankers and well-known partners from significant law firms. They were not inept, they were not amateurs. And that essentially they were trying to say, I'm not allowed to control the case, therefore I don't have any obligations. And that's where the court drew the line. So I don't think, and again, the Association of Litigation Funders of England and Wales weighed in and wasn't defending this particular case, but was defending the principles that you're both talking about. And the court balanced that by saying you've got to be proportional.
Yeah.
It wasn't, you're not strictly liable, you're not an insurer. of the success of the case.
Right, and I just want to agree. I agree with that very much, and I don't want to exaggerate the burden that any of these holdings or cases put on litigation funders. In cost-shifting jurisdictions, the rules are what they are, and they're not really too surprising. In my case, it really was quite exceptional. Anti-suit injunctions are not issued every day, and it was only in the case because of the underlying existence of that anti-suit injunction that there was ultimately any liability imposed on any funder. So I don't think anything should, anything from these cases casts any doubt on the fundamental role, or for that matter, the fundamental importance of litigation funding in providing justice in the United States and elsewhere.
We've gone over, but we wanted to thank you all, and we'll not hold you hostage for
Thank you very much. That was excellent.